You're welcome to this presentation. This presentation is a continuation of the series on defenses of criminal liability. And we have examined various types of defenses of criminal liability. Today, we'll be looking at the defense of compulsion. We'll be looking at the defense of extraordinary emergency. And also, we'll look at the defense of we'll look at provocation as a defense to the offense of assault. I will share my slides in a minute. So we'll be looking at defenses of compulsion, extraordinary emergency, and provocation as a defense for assault. The learning objective. At the end of the presentation, students should be able to understand the judicial and statutory authorities governing the defenses of compulsion, extraordinary emergency, and provocation as a defense for assault. And for the learning outcome, we expect that at the end of the lectures, students should be able to explain and apply statutory provisions and judicial authorities governing the defenses of compulsion, extraordinary emergency, and provocation as a defense for assault. So we'll look at compulsion first. A defendant, just a minute. A defendant who commits an offense as a result of threat or compulsion can escape criminal liability under the provisions of Section 32, subsection 4 of the Criminal Code and Section 57 of the Penal Code. So if you are subjected to a threat or compulsion and you are forced to do an act or omission that amounts to an offense, in certain circumstances, the law will allow you to escape from criminal liability. Now, the nature of the threat must be of instant death under the Penal Code. So it's not all kinds of threats that are covered. The threat must be of instant death under the Penal Code or immediate death or grievous harm under the Criminal Code. The requirement of the threat being instant or immediate is to underscore the fact that the person threatened is boxed into a corner and does not have the opportunity to seek the assistance of legal authorities. Now, if somebody threatens you or compels you or forces you to do something, he issues a threat that is going to force you to do something. If that threat is not instant or immediate, then you may not be allowed to rely on the defense, because the idea is you are under a constraint. You are boxed into a corner and somebody is threatening you with instant or immediate death or grievous harm, that if you don't do something, then you are going to be killed or is going to inflict grievous bodily harm on you. So the idea is you are boxed into a corner and you don't have any choice. But if the threat were to be a threat that is to be carried out 24 hours time or 48 hours time or at some other time in the future, that kind of threat will not suffice for the purpose of this provision, because you have the opportunity to seek the assistance of legal authorities that, oh, this man is threatening me to do this. And he has threatened that if I don't do it, then he's going to kill me or he's going to grievously injure me, in which case the legal authorities will come to your aid. So the threat must be of instant death or immediate death. We also need to note that the scope of the defense is wider under the Criminal Code. Under the Criminal Code, the threat must relate to death or grievous harm. So if the person is threatening to inflict grievous harm on you, that threat would entitle you to rely on the defense. But whereas under the Penal Code, the scope of the defense is limited only to instant death Under both codes, compulsion is not a defense to offenses punishable with death. Now, I remember in a previous class, somebody asked, what if somebody threatens me, threatens to kill me unless I kill another person? And I remember I told the person that the law does not allow you to place a higher premium on your life than the life of another. So under both codes, compulsion is not a defense to offenses punishable with death. So in other words, you cannot say A threatened to kill me unless I kill B. So I have killed B in order to preserve myself from instant or immediate death in the hands of A. The law will not allow that. Under both codes, compulsion is not a defense to offenses punishable with death. The criminal code also excludes the application of defense of compulsion to an offense of which grievous harm to the person of another or an intention to cause such harm is an element. So in the same vein, under the criminal code, you cannot say A threatens to injure me if I don't injure another person. It threatens to injure me if I don't injure another person. So the application of the defense of compulsion to an offense of which grievous harm to the person of another or an intention to cause such harm is an element will not entitle you to the defense. The defense of compulsion, is not a defense to offenses punishable with death. We've already said that. And under the criminal code, it excludes the application of the defense of compulsion to an offense of which grievous harm to the person of another or an intention to cause such harm is an element. So you cannot say that because you are threatened, you are to do grievous harm to the person of another. That defense will not avail you in that circumstance. Compulsion does not excuse grievous harm to another. It only protects against threat of grievous harm to self. It does not excuse grievous harm to another. It only protects against threat of grievous harm to self. Now, this may be contrasted with the position under English law, where in R and Right, 2000 Criminal Law Report at page 510, threats against the defendant's boyfriend suffice. Now, if somebody is threatening to injure you, to inflict grievous bodily harm on you, as a result of which you committed an offense, that defense will avail you, of course, provided that the offense you committed is not such as to cause death or grievous harm to another. Okay? But what we are saying here is that the defense of compulsion only protects you against threat of grievous harm to yourself. So if somebody is threatening to inflict grievous harm on another person, threatens to inflict grievous harm on another person, that defense will not avail you to come to the aid of that person. Just like in R and Right, threats against the defendant's boyfriend suffice. The defense allows you to not surrender to threat or compulsion if somebody is threatening to injure another person. That's under English law. But under our law, the scope of the defense is not wide enough to cover that. Under both codes, compulsion is not applicable to a person. That's another exception. Under both the penal code and the criminal code, compulsion is not applicable to a person who brings himself to a state of compulsion. So if you bring yourself under a situation to which somebody now threatens you, then you cannot use that threat as a defense because you are the one who brought yourself under that state. Now, there is also the defense of compulsion that is available under Section 33 of the Criminal Code, which excuses a wife of a Christian marriage from criminal liability when she is compelled by her husband to do an act or omission, provided that it is not an offense punishable with death, or an offense of which grievous harm to the person of another, or an intention to cause such harm is an element. So what this provision does is that it excuses a wife of a Christian marriage from criminal liability when she's compelled by her husband to do an act or omission. So if a wife of a Christian marriage is compelled by her husband to slap somebody, that is an assault. Okay? The husband compels her to slap somebody, then she will have a defense, provided she is the wife of a Christian marriage. Now, I'm sure you will agree with me that such provision is no longer a provision that we can defend, in this current, climate, because these are some of the defenses under the law that were an offshoot of an era in which women are subjugated to their husband. A wife, it was at such times when women cannot even hold property. They don't have a life of their own outside of the life they have with their husband. So this provision is definitely not one that we can defend in contemporary times. And also another objection to the provision is that it may also be viewed as discriminatory because it only excuses a wife of a Christian marriage. What of a wife of a non-Christian marriage? Why will the law confer a special privilege on the wife of a Christian marriage and not on the wife of other types of marriages? Of course, you will understand that the criminal code that we adopted in Nigeria was a criminal code that was drafted for a Christian community. The code was originally drafted to replace the common law. It was adopted in Queensland and it was brought to Nigeria. So you can understand that it reflected that, the predominance of the Christian view of marriage in the English society, and that was unfortunately brought into the criminal code that was adopted, and made applicable to the whole of Nigeria. So that provision is no longer a justifiable provision, and consequently, it has been removed from the Criminal Law of Lagos State 2011. Now we want to look at the defense of extraordinary emergency. This is governed by Section 26 of the Criminal Code and Section 33 of the Criminal Law of Lagos State. These sections provides for the defense of extraordinary emergency. Now, the first point to note about the defense is that there's no restriction on the scope of offenses to which the defense applies. The defense is potentially applicable to any offense. The second point is that the defense is made subject to the express provision of the code or the Criminal Law of Lagos State relating to acts done in compulsion or provocation or in self-defense. In other words, if the facts of a case were such as to entitle the defendant to raise the defense of compulsion or to raise the defense of provocation or to raise a plea of self-defense, then the defendant will not be able to raise the plea of extraordinary emergency. If a defendant can, within the circumstances, raise a defense of compulsion or provocation or self-defense, then that defendant will not be able to raise the plea of extraordinary emergency. The provision excuses from criminal liability for an act done or omission made under such circumstances of sudden or extraordinary emergency. Circumstances of sudden or extraordinary emergency that an ordinary person possessing ordinary power of self-control could not reasonably be expected to act otherwise. Okay, in previous presentation, I gave the example of somebody who is driving a vehicle on the road at a very reasonable speed, having regard to the traffic on the road and the pedestrians, using the road at the same time. And a toddler suddenly runs across the road at such a distance that it is not possible for him to match his brake and be able to avoid hitting the toddler. And is left with two choices. One, either to knock down the toddler and possibly kill the toddler, or swerve off the main road to the side of the road and maybe then hit, cartons of soft drinks that are packed on the side of the road. And at that moment, that's a situation of extraordinary emergency. There was an emergency, and he had to act on the spur of the moment. So if he acted on the spur of the moment, swerved off the road, avoided the toddler, runs into the cartons of soft drinks, and damages those cartons of soft drinks, that will not constitute the offense of damage to property, because in that circumstance, there was a circumstance of sudden or extraordinary emergency that he had to deal with at that point in time. An interesting case that raises the applicability of the defense of necessity or extraordinary emergency under English law to the offense of murder is a case of R versus Dudley and Stevens, 1884, 14 QBD at page 273. That was a case involving, some persons who were, traveling on the sea. And as a result of storm, they had to abandon their vessel and use a makeshift vessel. And the waves and the storm, drove them, over 1,000 miles away from the land. And in the course of time, there was no food to eat, there was no water to drink. And ultimately, they all agreed, and they agreed to kill one of them. And a young boy who was a member of the team was killed, and the others fed on him for 4 days, after which they were rescued. Of course, they were charged with murder, and they tried to raise a defense of necessity or a defense of emergency. And the court said that that kind of defense cannot avail them, and that the law will not allow them, to place a higher premium on their own lives at the expense of the life of another. So that clearly showed that that defense will not avail them. Of course, if the facts were also to arise under the provisions of Section 26 of the Criminal Code, the court will probably have reached the same conclusion. They cannot raise a plea of self-defense, for instance, because there was the poor young boy whose life was sacrificed did not constitute any threat to their own life, so they could not have raised a plea of self-defense. So that was a situation in which they cannot claim a defense of necessity or a defense of extraordinary emergency. Then there is a defense of provocation as a defense for assault. We will also come to study provocation when we come to cases of voluntary manslaughter. But here we are focused on provocation as a defense for assault. Section 24 of the Criminal Code allows a defense of provocation to a charge of assault. Okay? The law allows you, if somebody provokes you, and you can see the definition of provocation in Section 283(1) of the Criminal Code. If you are provoked, somebody has done a wrongful assault or insult against your person, as a result of which you are provoked. And as a result of that, you are deprived by the provocation of your power of self-control, and you acted suddenly before there is time for passion to cool, and you assaulted the person who provoked you, then the law would allow you to raise a plea of provocation as a defense for assault. But the force used in the assault must not be disproportionate to the provocation. And it must not be the kind of assault that is intended and is not such as is likely to cause death or grievous bodily harm. So when you are provoked and you assaulted another, the force used in the assault must be proportionate. If you use a disproportionate force, then that will disentitle you to rely on the defense. For instance, if somebody abused you with very foul language, and you take a plank and hit him on the head, thereby, causing grievous harm. Yes, you might have been provoked by being insulted, by being abused, but that does not justify you using a plank to assault in response to that provocation, because the nature of that assault is such as to cause grievous harm. So that would disentitle you to rely on that assault or to rely on that provocation as a defense for assault, and you'll be liable for causing grievous harm. Like I said earlier, you can see section 283 of the Criminal Code for the definition of provocation in relation to assault. Now, the person relying on the plea of provocation for assault will not be allowed to rely on a lawful act as a basis of provocation for an assault. You can see the third paragraph of section 283 of the Criminal Code. So if, for instance, a policeman is trying to arrest you, or a citizen exercising his right to arrest as a private citizen tries to arrest you after you have committed an offense, you cannot use the process of arrest as a justification for assault, because in trying to arrest you, they are entitled to take physical control of you and to use such force as is reasonably necessary to secure your arrest. So you cannot use that lawful act of arrest as a basis of provocation for an assault, because what they were doing is lawfully exercising a right of arrest. So if you assault the person trying to exercise a lawful right of arrest over you, then that defense will not avail, and you'll be liable for the offense of assault. Like now, or like in the case of murder, where provocation is a partial defense in cases of voluntary manslaughter, which will reduce the offense from murder to manslaughter, provocation is a complete defense to assault. So if you have been provoked and you responded by assault, and the amount of force used in effecting the assault is proportionate to the provocation, then the law will give you a complete defense to the offense of assault. So that is a presentation on the defense of compulsion, on the defense of extraordinary emergency, and on provocation as a defense for assault. So please listen to this presentation and come prepared with your questions and requests for clarification. Please do not forget to subscribe to the YouTube channel, so that as soon as I post additional videos, you'll be able to have immediate access to it. Thank you very much, and God bless.